So.
Hi, yeah, I believe I reported a couple months ago that myself and Ann and Wendy Jones, we were working with managed care organizations to get them to fund a part-time reentry position on the jail behavioral health team. And after much back and forth and sideways and up and downs, the MCOs declined to participate in funding a part-time reentry staff person. But then they proceeded to ask us if we would, provide them with certain information and do certain activities. And eventually we said no, we would not do anything on their behalf without payment for those services. The MCOs are obligated by the healthcare authority to provide certain reentry services to their members who are incarcerated. And we did not want to, since they're, making oodles and oodles of money, we did not want to participate on their behalf and provide them with any services without due reimbursement. So that is not going to happen. We're still going to be able to have some reentry services coming through the jail behavioral health program, but they just won't be funded with MCO funds. So that's where we stand at this point. And I guess the only thing I would ask is that we have your support on that, on continuing to hold firm with the MCOs. I think this is a really important issue. That these organizations that are pulling in a lot of profit and using public funds to do so, that they need to be a part of our communities. They need to support our communities in beneficial ways. And so I guess I would ask that you just stand by us and support us in this endeavor. And that's all I have. Any questions or thoughts?
Jackie, this is Stephen.
Yeah.
Is this the MCOs collectively speaking with one voice?
Pretty much, yeah. We had a person who was doing most of the talking with us, but she was acting on behalf of the 5 MCOs.
Can you circulate to us the contractual requirement or whatever you were referring to that calls on them to provide some level of reentry services so that we can see that? And I would suggest.
Yeah, I think I pulled something up the other day. I think I can send you something. Yeah.
I would suggest to the co-chairs that we consider recommending the task force write to the MCOs asking that they fulfill their contractual obligations and reconsider that decision.
I will say that I think they think they're already doing that. What they have done is hired staff. However, these staff are officed in places like Tukwila and Olympia, and they'll be coming up like maybe once a month or twice a month on say a Friday or whatever. So they're not likely to catch all of their members. We have left them, we have told them that they can meet with their members in the same way as that other public meet with people when they come to the jail. They just won't get any special treatment from us. So I think they think they're fulfilling their obligations by hiring those reentry staff and by trying to make the connections that they're making and by coming up when they do. I'm not sure that they aren't fulfilling those, but I think they could do a better job, I guess, is what I'm saying.
You think the healthcare authority also thinks they're fulfilling their obligations?
That remains to be seen. That's a good question. I don't know. Yeah. I think one of the things about it is our jail is so crowded and so small. It's really hard, and so understaffed that it's really hard it would be difficult and challenging to see 5 MCOs coming in and trying to meet with all these various people. So part of our offer was, if we do this work on your behalf, it's good for everybody. Yeah, so they declined. I think I mean, quite literally, I think they want to keep their profits to themselves. So, yeah, Arlene, you're muted. You have a little icon on the left-hand side of your screen. Oh, okay. Maybe you can write a message.
Can you adjust the volume, Arlene?
So I think I know why Arlene can't speak, and that's when you go to mute and you hit your button on the computer, that screws up the whole transmission. And if you take your mouse and you move it to the microphone and mute thing, and there's a little arrow up, it gives you a selection on select microphones. Then you select the microphone at the top. You should be able to get on. I've experienced these problems, I know.
So you're saying if you do it from the keyboard, that's gonna mess you up.
Right. You hit mute on your keyboard and it screws up the whole transmission.
I didn't even know you could do that. So. Okay, well, anybody else while we're waiting? Any other thoughts?
I think what you've been talking about is really important, that we revisit this and we bring information back to the full task force. As Stephen Gockley has said, we've talked about reentry and the importance of it, and making sure there's adequate support. So any more information that you have on what you need, or any input that the task force can provide to the MCOs to make sure that we get adequate reentry, I want feedback as much as possible.
Bill also has his hand raised.
Sorry?
Go ahead, Bill.
Oh, just two things. I may have to leave the meeting early as well. I'm just monitoring something that's going on out in the field. But one question that came up at the last meeting, if we're just waiting, was when the FBI stopped collecting booking data on Hispanics as a category in 2019. We had the percentage broken down going back to the 1990s, and then our system was adjusted to change to what the new FBI requirements are. But we were able to get that reinstated. So from about 3 weeks ago forward, we'll have that data and have it available for you in whatever frequency you want, monthly or quarterly. So that's improved. And the other thing I want to mention that's not on the agenda, if we just have a minute, is we're very concerned about the Crisis Stabilization Center. From the beginning, law enforcement has advocated, and we're given.
Hey, what are you doing in there? Oops, sorry. My apologies. I thought I was on mute.
Oh, no, that's okay. That it was going to be able to accommodate with involuntary holds for people in grave dangers to themselves or others, which is a category. The hospital has changed their policies over there. They're very difficult to deal with. We had a kid that was delusional, was shooting at people that weren't there. We took him in, and the hospital had him out of there in about 10 minutes, turned him loose, a 17-year-old. So that continues to be a problem. We're addressing this with Ann and other folks from the health department. That's coming up, but that's something looming, and I consider it essential that we get this fixed if we're going to be using this as a diversion from jail for people in mental health crisis. So thank you.
I just want to say thank you, Bill, for taking the time and the effort to reinstate the tracking of Hispanic people coming into the jail and being in the jail. We know that that's one of the groups in which we do the least well. It's one of the groups that's overrepresented in many of our statistics. And so what you did was quite good and will be quite helpful to all of us going forward, I think. Thank you.
Yeah, the one issue is you won't have it for other jurisdictions not collecting it to be able to do the comparisons, but at least we'll be doing it internally.
At least we'll know our numbers. Yeah. Thanks again. Yeah.
Thank you, Sheriff Alpha. Appreciate that input. Also, I think we will need to put that crisis stabilization unit and involuntary holds on the next agenda to see where we're at and what needs to be done. And then the Hispanic data is definitely important. And we also want to pass that on to the index committee so that they have that information as we work on tracking more data and having accurate data. Any other comments? And Jill, if you could actually change the view to hide the agenda just so that I can see all the participants. Thank you.
And Arlene has her hand raised. Arlene, are you able to speak now? No? Okay.
Sorry, Arlene. Maybe we can get your input at the next meeting if you want to take notes and can get them off to Jill. Even if you want to email Jill, maybe she can send your feedback that way. Is there any other questions on the other business that Sheriff Elfo had? Seeing none, I believe Deborah Garrett is up on the pretrial services group for the next agenda topic. Do you want to proceed?
Sure. Can everybody hear me? Okay. Unfortunately, I don't have as much to tell you as I would like. The pandemic has changed many, many things about life at the courthouse. And one of the things that's changed is, and I'll talk more about the specifics of this in a little while when I talk with Rajiv Majimdar, who's also going to be talking. But one of the things that's changed is that the Supreme Court since early in the pandemic, since March, has urged the trial courts and authorized the trial courts to release as many people as possible without endangering public safety. And what our judges in the Superior Court have taken this to mean is that unless there are extenuating circumstances, we generally release on personal recognizance with no bail. Pretty much everyone who is charged with a property crime that doesn't involve violence, and pretty much everybody who's charged with drug crimes. That is not what we had done previously, and we have put some of those people on pretrial services, but the manner of pretrial services has changed too, because there's no in-person contact. So the pretrial services by phone, which were a part of the picture, remain, but other pretrial services like the, reporting to the office don't continue in that form. And this has been true since the middle of March. So we're going on 6 months now. Talk about bad timing. We were just about to start the use of the risk assessment tool that you've heard us talk about for a couple years now. Having identified the right tool and done all of the fine tuning that was necessary, we then took advantage of an offer from the Arnold Foundation to train our people. Well, first to install the software to run this assessment, and then to train our people. And literally, we were going to start using the risk assessment tool the week that we got the governor's order and pretty much everything shut down in the middle of March. So the timing was just terrible for that. We had been using pretrial services while we got the risk assessment tool up and running. So we've been using pretrial services since the fall of 2019, but determining who should be on pretrial services and the level of services that they should have has been done just by decision making by judicial officers, and they have not gotten the information in the format that the risk assessment tool would give it. So that's been a disadvantage for the judicial officers, but still we've been able to utilize pretrial services, and it's been a good thing. As for the future of pretrial services, I'm concerned because I know that the budget for the Superior Court has to be cut back by something like $800,000 for going into 2020. And pretrial services is going to take its share, and I hope no more, but it'll have to take its share of those cuts. So I don't know what that means in terms of the staffing or the work that the pretrial services department does, if that makes sense. I don't know if the work will be the same, or if it'll be necessary for the pretrial services department to focus more on preparation of the assessment tool, or whether it can give full attention to the actual services, which I think is personally I think is the more important goal. That's where we stand with pretrial services. We're still not up and running. The statistics for the jail are interesting in that they were, excuse me, something just came across my screen. The statistics went way down in the report of April. They went down, and even more so in May. The report of May is for the month of April. So for the month of April, you can see the Supreme Court's directive being taken seriously in Whatcom County. And the number of people in the jail went from 143 in the beginning of March to 91 in the beginning of May. And since then, that number has gone up. And as of the most recent report I've seen, I guess there was one yesterday, but the most recent one I've seen was last week. I'm supposedly on vacation this week. But the report that I saw last week had the jail population at 155, which is concerning. The full capacity of the jail is 212. So we're not looking at getting to or exceeding capacity or having to send people to other counties as we were, in the fall of 2019. But unfortunately, even if you only jail pre-trial the people who are thought to be a serious risk to community safety, we're not able to have jury trials yet. And we expect that that's going to change. We're working very hard on it. But if anybody's interested, I can give you a detailed list of what you need to have for a jury trial, and it's huge. We don't have the facilities in the county courthouse, so we have to look at outside places, and it's just, it has been a very complex endeavor. We think we're getting close, but we also know that when we can do jury trials, we're not going to be able to do more than one, possibly two at a time. So cutting back that backlog is going to take quite a while. And while that's what empties out the jail, is people's cases going to trial. So when we have a limit on people's cases going to trial, that's going to create a backlog in the jail. And we try to minimize that backlog by releasing as many people as we can. But there are a lot of people who really cannot be safely released into the community without some pretty restrictive conditions, including bail. So that's where we are on pretrial services. It's, I would say it's in a state of flux right now as we deal with the pandemic. And as times get more normal, I think the statistics regarding pretrial services will get more predictable. And that's pretty much what I have.
Thank you, Judge Garrett. I really appreciate your input on that. And I do have concerns about jury trials, so maybe we can touch base on that towards the end of this meeting on other business. Is there any questions for Judge Garrett at this time? And Jill, I can't see hands raised.
There are no hands raised.
Thank you. I'd like to proceed with Rajiv Majimdar. He's the city prosecutor for the city of Blaine, and he's also prosecuted in other jurisdictions, as well as I think, are you just finishing the State Bar President Association this month, I believe? Rajiv, if you could give us some
3 days left.
3 days left. If you could give us some input on pretrial services that are currently being done in the municipal courts, how that works, and the importance of what you feel is necessary for Superior Court cases.
Certainly, a little background first. It's really lovely to see so many of you that I've come to know over a decade of being here in Whatcom County and haven't gotten to see through the pandemic. So it's nice to see all the some regular faces, a lot of new faces also, but nice to see you. And it's been a really interesting year for me being state bar president, because I've traveled all around the state talking to other communities and how they're dealing with things. A little background from my understanding of Whatcom County and municipal pretrial services is that at a time, many of us had our own probation services, and we've migrated over time all to contracting with district court probation to provide those pretrial services, except Ferndale, which maintains its own probation officer. Blaine had one as recently as within 15 years, Madam Court Administrator? You're on mute, but I can just assume you're agreeing with me in some fashion.
2007.
2007. So, but we've all migrated to district court probation. And I think the consensus is, except for Ferndale, which always likes to go its own way, the consensus is we're really pleased with the level of support, and it's probably our most effective tool that we use in keeping people out of jail pre-trial and even post-trial. It gives us a lot of alternatives. The fact of them, and now that we've added friendship diversion services to our roster and integrated them into working and collaborating with Whatcom District Court probation, we've just had amazing success, because if you can monitor people for substance use, because that's the public health concern, you don't have to have them in jail. If you can arrange to have vehicles clubbed, so you're not concerned about people driving or habitually driving their vehicles, that can be something that can be resolved. If you can put a monitor on someone's ankle that detects when they're drinking, they don't even have to come in and interrupt their life. They can continue going to work without having to have them incarcerated. Pretrial services is a pretty strong and regular component of release conditions when we're not dealing with first-time offenders. Probation has a real district court probation. I call them district court probation. I know we're talking about pretrial services, but it's a very well-oiled machine. They're very well trained. They're very enthused. I think the judicial officers are very appreciative of what they do. They're very responsible and knowledgeable. They're well trained. But the real fact of the matter is it keeps us from having to keep people in the jail. And while that has always been the case, and I like to think that in some of our jurisdictions, we were ahead of the curve in trying to not keep people in jail, the coronavirus and the deteriorating structural conditions of the jail that have both imposed booking conditions has left us in a place where we were already very well prepared with alternatives. And so while the judges may grumble sometimes about not being able to book certain people or wondering why some certain people aren't booked, I think we've adapted really well in the small cities because we have all these services lined up. And if I have, even Judge Garrett was talking about property crimes, But if I have property crimes which are pretty directly connected, or habitual property crimes happening, but they're pretty directly connected to substance abuse, and we think that's the real driver, or even they're really connected to a mental health issue, the district court probation unit has a mental health, John Hooper is the district court probation officer who specializes in mental health performance. So it also allows us to get people connected with services. I happen to also be Bellingham's mental health court special prosecutor. So I'm really familiar with all the potential services the county has to provide. And probation is a great way to get that information to defendants. It lets us get defendants. We're not only dealing with preventing them from violating their release conditions and monitoring them and giving them an option not to violate those release conditions, but we're also giving them the resources that can sometimes channel people out of this path that keeps them interacting with the court system and the threat of jail. I think it's been overwhelming success. And I arrived in Whatcom County 12 years ago, and the entire time since then, I have always been, and I think the correct word is flabbergasted, that there's defendants who would rather be charged with a felony so that they don't have to be monitored in the ways that they would be if they got a misdemeanor, because there are more restrictions on you and monitoring options available to courts that get charged with a misdemeanor than there are if you get charged with a felony on pretrial. I can essentially go out and engage in all kinds of mayhem behavior. Also, we have now GPS monitoring pretty effectively and widely available to us through FDS. And that's been really fantastic for us for enforcing no contact violation. People who are violating no contact orders, or people involved in pretty serious domestic violence incidents where we're concerned about their approaching. And I have so many tools. It's always just been very puzzling to me that the felons and the people accused of more serious crimes in our community, we have a lesser ability to actually monitor them than we do misdemeanors. And I've always, I don't know about the internal bureaucratic politics and whatnot, but I always just thought, why doesn't Superior Court just contract the district court? But of course I know there's all kinds of backstory and background and politics to this. But the long story short is all the small cities have come up with a very effective tool to keep people out of, or give a great alternative to judicial officers to keep people out of jail and to protect public safety. We've been real pleased with it and how it works. Does anyone have any questions about how we use it? I don't know how familiar all of you are with the process.
I just want to point out one thing, Rajiv, and hi. But what I want to point out is that the law is different for pretrial misdemeanors than it is for pretrial felonies. And it's not a question of the Superior Court just not getting with the program while the district court and the smaller cities courts do. In fact, the law is pretty clear that Superior Court, the law is pretty clear that a court can't mandate a person to do much unless and until they're convicted of the crime, because they're innocent until proven guilty. Now, we have a couple of statutes that, as I understand it, and I'm not an expert on misdemeanor law, but we have a couple statutes that permit monitoring while people are, of people who are accused of misdemeanors, which means people who are in the municipal courts and the district court. And that monitoring and other services that are required, can be required there in a way that they can't be. For example, you can take away the right to drive in the lower courts. You can't take that away in Superior Court unless and until a person's been convicted of an offense that involves taking away the right to drive. So, I too have been flabbergasted at how few services are available in Superior Court pretrial as compared to district court. But that formula, illogical as it is set up at the state level, not the local level. And so that's part of the challenge that we all have to deal with.
Of course, though I did just lose that argument this morning in custody regarding right to drive in misdemeanor world as well. But the reason I put all these thoughts out there is because I know this group is holistically looking at all the systems. So I didn't mean to imply the superior court system was in any ways responsible for some lack of oversight. But if there's going to be a solution, it's going to require prosecution, defense, the courts, and all of you that are here together. So I want to bring just the message that it's just been a great tool for us to keep people out of the jail system. And especially during coronavirus, well, Judge Bobbing, who's the judge of Everson and Sumas and Blaine, he's been highly, highly cognizant. He does not want to put people in custody during coronavirus. He's been bending over backwards, except where there's public safety concerns, to achieve alternative methods. And I've been really proud of his leadership on those issues. But I think it's really important for all of us from a public safety standpoint. I mean, we have to minimize the threat to, you know, the jail staff, the defendants themselves, and all of our community. But pretrial services are a fantastic way. And you give judges more tools, there's better solutions that come out of it. If you give a judge minimal tools, it's like when you have a hammer, everything looks like a nail. You have to have a whole toolbox.
Stephen Gockley has his hand raised.
Go ahead, Stephen.
Thank you, Rajiv. It's great to see you also. As to the dialogue you and Judge Garrett have just had, is there any possibility, because I don't know the law in this area, is there any possibility for a felony defendant in Superior Court to waive some of their protections against pretrial release conditions in exchange for release? Or is there a potential statutory fix to that roadblock in Superior Court that perhaps we could put our advocacy hats on to move forward?
There's statutory fixes to everything, and people can generally waive rights, but the defense attorney in me wants to say I would be afraid of a coercive effect. We'll let you out of jail if you waive your constitutional right, but I'll pass to Judge Garrett.
Well, Maya Lisa is also on the call, so I'd welcome her view on that as well.
Well, my view, and I'm Judge Garrett, my view is not really. I've tried to order various components, various requirements on pretrial release in a situation where I thought it was iffy and wanted to put a little more support around the defendant, and mostly have not been able to do that and have been told accurately by defense attorneys the court doesn't have authority to do that. The statute that gives the district court and municipal courts more leeway is going to be tested in the Supreme Court. There have been some decisions recently that throw into question that court's ability constitutionally to do that, to put pretrial restrictions on. However, there's a clear statute that says that it can be done and enumerates the types of crimes in which it can be done. They're not felony crimes. There are questions about the constitutionality of that statute, and we'll see how that gets resolved. But that's the situation in the meantime. And yes, people can agree to conditions that they wouldn't otherwise have to agree to, but my experience is that they generally don't, particularly defendants who are represented by counsel. And I think it is a real question. If you say, well, you're getting out of jail depends on you doing X, that's pretty coercive. Yeah.
Judge Garrett, I have a question for you. One of the defendants today in court had 2 prior DUIs. This is his 3rd. He's got a deferred prosecution on one of them. And in misdemeanor courts, for sure, without looking at the statute, they're required to have 24/7 monitoring if there's a prior DUI. Is that the same on felony DUI charges?
I don't think so, but I don't bring the charges, and so I don't know what all of the charging options are. I think maybe Eric Ritchie would be a better authority on that.
Sorry, I missed the question. What was it?
So on misdemeanor DUI charges, when there's been a prior, even outside the 10 years, the municipal courts are required to have some type of 24/7 monitoring, whether it be an IID or monitoring by probation, or it can be both. And I know that we've been doing this for several years. We have to submit notification to DOL. Is that the same for felony DUIs?
No.
I knew you'd know the answer in one word.
It just seems, as Raj pointed out earlier, flabbergasting for somebody that's had 2 prior DUIs, and then this one's a third, but since there's a deferred prosecution, it's not a felony, that there's these mandatory convictions that have to be, or mandatory orders to be put on prior to a conviction, that if he wouldn't have had that deferred prosecution, he probably wouldn't have those pretrial conditions.
Right. And so, you know, I understand what you're talking about when you're talking about felony DUIs and DUIs in district court, because those are, you know, so similar in so many ways. And you know, the felony DUI, after having been convicted a number of times, and it's more dangerous and more pretrial stuff should be happening. And I mean, that just makes sense. But I think everyone also needs to understand, and I'm not advocating, I'm not saying that we don't want more tools for the judge, but you have to understand that cases in Superior Court are more dangerous, more risky to public safety, and that's what makes the. I mean, that's the difference. That's the way why the legislature looks at them differently. You know, and that's why bail is probably more often used in Superior Court than in District Court, because people are more of a danger to the community. Anyway, I just want to throw that out.
Maya was about to speak up earlier and got cut off. No.
Is there any other questions or comments? I'm seeing none. Jill, is there any hands raised that I'm missing?
No hands are raised.
Okay, well, thank you all.
Thank you, Judge Garrett, and thank you, Rajiv. I really appreciate your participation, both of you.
Thanks. I just want to say I really appreciate everything you guys are doing. It's really helpful to our community, and it shows real leadership, all of you being involved in this. Thank you so much for having me.
Thank you. The next item on the agenda was a racial equity toolkit, and we were hoping to have some information and input on that. We don't have it yet. Jill pointed out that we're hoping to get some information put out to the committees prior to our next meeting. So if you see that with the next agenda, please review the toolkit that's being prepared to see if that's something we're interested in using and to bring forward to the next task force meeting on any thoughts or input you have on the racial equity toolkit that we're looking into. And then, is there any questions on that before I move forward? Hearing and seeing none, I'm gonna go on to other business. Judge Garrett looks like she disappeared. I do have a question, as she mentioned, on jury trials. Is there any input from Maya or Eric or Rajiv on jury? Oh, there's Deborah Garrett.
Yep. I just walked off to get a glass of water.
Great. So I just, you know, curious on jury trials. I know I've got a couple different defendants in our court that have expressed interest. In fact, one's coming to court on Wednesday and said he wanted a jury trial. And we don't want to be the guinea pigs. So what's happening in the other courts, and any suggestions to proceed, because we don't want to put these out for the next 2 years.
Well, I can tell you from the Superior Court perspective. Superior Court jury trials involve 12 jurors, and generally we have 2 alternates, not always, but usually, especially if the trial's more than a day or 2. So we need space for 14, maybe 15 jurors. And in order to do that with everybody socially distanced, 2 of our courtrooms just flat out will not accommodate that many people. There's usually, in addition to the maybe 14 jurors, there are 10 to 12 other people between the bailiff, the clerk, the court reporter, the judge, the lawyers, and any police who may be their security people. So you're looking at a room that has to accommodate maybe 25 to 30 people for a jury trial in Superior Court. 2 of our courtrooms arguably can do that. There's no room for audience, but that's okay. We can have the audience, if there is an audience, in a different place, and they can watch by closed circuit TV. The big problem for us is finding a place where you can do jury selection. And that may not sound like a big deal, but I put in our 12th administrative order that we issued a month or 2 ago about starting up jury trials, I put a lot of the conditions that we need in that order so that people reading the order could see that you need to have a building that's big enough to assemble all of the jurors. And for a routine jury trial, you might need 40, 45 potential jurors. For a bigger or more controversial jury trial, or a sex case in which more jurors generally have strong feelings or biases, and so more of them get excused, you need up to 70 people, and of course for a really big case, more than that. And having a room where those people can gather and still stay distanced, and a room that room also has to accommodate, it has to have enough bathrooms, it has to be handicap accessible, it has to have a private place for the defendant to talk with his or her lawyer. It has to be workable for security purposes. In other words, the sheriff's people have to say, okay, there has to be adequate parking, and it has to be on a bus line. Put all that together, and finding a place to do jury trials is more complicated than you might think. And so far, what we have found is that the hotels that we've talked with have rooms that are, the only places that we've talked with that have rooms that are arguably workable are so expensive that it's just out of the question, like several $1,000s a day. Recently, we've toured an older building that is available to us that we think might work. And so we're trying to figure out plans for doing that, trying to figure out whether that site will work. If it will, we're going to start up jury trials in about 4 weeks. We're continuing to summons jurors, potential jurors, because there's a 6-week lead time on that. So we're optimistic that we're getting there. It's going to be, what we're going to do is use the larger courtroom, and the jury will be not in the jury box, but in the audience part of the room. The lawyers' tables will be turned around. And then the other large courtroom, they're both on the same floor, will be used as a jury room. That cuts back on our facilities to do other kinds of things, including criminal motions calendars, but we figure we can make adjustments to the scheduling of those other things to accommodate the jury trial. I just wish we could accommodate more than one at a time, and so ideally we could find a jury selection facility that might also permit trials, but there's a lot to put together there. In addition to all the other things I just told you, there's also the technology that is especially, that has to be there during the trial itself. And so our IT people are closely involved in all of that. I suspect I've talked for too long, but that's an idea of the considerations.
Thank you. I appreciate that, Judge Garrett. And if you guys move forward and have a location, and anybody has trials in the near future, I would definitely want input on how it went and things that needed to be changed.
That's a good idea. Yes. We'll keep you in the pipeline.
Appreciate it.
Good.
Maya?
Nope.
Maya, we're not hearing you.
Thank you, Maya. Unfortunately, I don't know what the issue is, but
Try the Eric Ritchie trick where you click on that little arrow next to the microphone and select the microphone thingy.
Is that?
Eric. Hey.
Oh, great. Thanks. Good, nice trick, Eric. I was just going to share a discussion I had with a public defender in Skagit County yesterday. They have had a COVID-ready trial courtroom for, I don't know, it's got to be like 6 weeks now. I don't know. It's quite some time. They did some sort of restructuring of courtrooms they had, but they have yet to have a jury trial go forward. And the reluctant, I mean, I think there's a variety of reasons why defendants may be reluctant to go forward under what might be a nominally safe environment, but maybe not perceived as particularly fair necessarily, kind of depending on whether, you know, who's going to be reflected in the jury pool that actually shows up to serve. There are, so just to put it out there, that while we don't have a facility, even in a jurisdiction where facility is available, they have yet to go forward with a trial. So it's complicated. Thanks.
go ahead, Eric.
I'll just mention that there are a number of counties that have successfully had jury trials over the last couple months. They it took them a long time to develop a process, and they were able to, they're able to secure an extra building generally to do jury selection, but they were able to conduct trials after doing that. And anyway, I'm hopeful still that we'll be able to do that at some point here in Whatcom County. Anyway, I'll leave it at that.
Thank you. Is there any other questions or comments in reference to this topic? Hearing none. Sorry, I'm kind of moving here. Is there any other business that I've missed that's anybody's interested in? Subjects? Jill, do I have any other hands?
No hands are raised for other business.
Thank you. Is there any public comment today?
Thank you. We have 5 attendees today. If any of you would like to speak, please virtually raise your hand. Online, you can select the raise hand icon, or if you're calling by phone, press *9 now. And no one is raising their hand. Oh, wait, we have one. Okay, Heather, go ahead.
Hi, everybody. Can you see me or just hear me?
We can
just hear me. It's
just
great. Great. So a couple of things I just wanted to say. I'm seeing some comments on Facebook, which I know is not always the most reliable source, but about what's happening with our courts right now. And I'm not sure if it's true or not, but my understanding is that felony courts have been paused, right? We were just talking about that with no trials. But are people still coming in for misdemeanor issues and paying fines and being brought to the courthouse in groups in any way? I'm just seeing some comments on Facebook about the concerns around that and the personal safety people are feeling, and just wanted to share that with this committee as another area. And it could be completely not right, but when I read those, I felt a little bit worried and sad for that experience. And it sort of is aligned with what I think I'm understanding from the committee today about how the restrictions can be for pre-trial services or even pre-carceration. Some people think about it that way, can be so much more stringent for our misdemeanor population than our felony population. And just like, where's the common sense parts that we can try to change? So I don't know if that's a coherent comment, but I just felt like I should share that.
Heather, I'm sorry I missed part of it. I had to step out for just a second. But I did hear the comments about misdemeanor fines and what was going on with that. And I can tell you that the courts haven't been FTAing until just recently. Some of them still aren't ordering fines. Collections, we're allowing a lot more leniency than ever has happened, at least what I've seen in the misdemeanor courts. Bellingham Court recently posted on a court forum that they weren't FTAing or putting people in collections yet. Blaine has just recently started, but that's only after individuals have not responded to the court whatsoever. And if they have contacted us and asked for leniency or asked to be pulled from collections, we worked with everybody. So that's just on the misdemeanor levels. If I'm missing other parts, somebody else can give me some feedback for.
Well, I just want to point out one thing, and that is, I was amazed too when I became a judge and found out about the pretty much lack of any pretrial services at the Superior Court level. And evidently that's been true for a really long time, like, I don't know, 20 years at least. But the way it started was that the law recognized that felony crimes are more serious, and it imposed pretrial services through the Department of Corrections. But that practice stopped, especially as the Department of Corrections, like so many other state departments, lost its funding, or its funding diminished, and it gradually stopped doing those pretrial services. Meanwhile, municipalities and counties had done their probation departments all along, because they are county courts, not state courts. And so we have this pretty irrational situation, but that's how it developed. It didn't start out irrational, but when you take away the DOC involvement, there we are. And that's a statewide problem.
That's super helpful. Thank you for answering my question. And the other thing I'm curious about is, so we're sort of in this interesting experiment right now of a pandemic putting the pressure to keep incarceration down and releasing more people than normal. And I am very interested in what's happening with recidivism, and if we're seeing crime rates go up or continue, or and if people who are enrolled with pretrial services, is that changing that recidivism rate or not?
I think I'm unmuted. Is that, yeah. Those are good questions, both of them. My understanding is that there are a couple of ways people can violate pretrial services. If for minor violations, like they're supposed to call and they don't, that gets handled internally by our pretrial services unit. If all those cases came to court, that's just not feasible. But the main violation that a person can commit when they're on pretrial services is being accused of another crime, a new crime. And that requires that the case go before a judge or judicial officer to determine whether their conditions of release should be changed. We are seeing, frankly, a lot of new crimes. And I don't have statistics for you, but I've wondered about this, and I've talked about it with Eric Sigmar, the chief deputy at the prosecutor's office, and he indicates what I think I'm seeing on the bench, which is that people are, a lot of people who are released, there's drugs in the picture. Either they've been, they're accused of some kind of drug violation like possession, or they're accused of a theft crime that they did to support their drug habit. Well, when those people are released, and they still have the drug problem, and they're addicts. And so they will often reoffend. The good thing, if there is good, so we're seeing a lot of new crimes, frankly, on people that we've released. but the bulk of those crimes are less equal to or less serious than the crime that they were originally charged with. At least that's the trend. And, you know, there's exceptions to everything, but what we're seeing are, you know, people being accused of crimes that are also drug related and not crimes of violence. So there's that. So the news is not entirely good, but it's not entirely bad. And that's just preliminary, obviously. That's pretty anecdotal, but that's what I think the status is right now.
Thank you so much, Judge Garrett. And what I hear in that is that there's still treatment capacity issues in our community.
Thank you, Heather. Attendee Cole Harvey has a hand raised. Cole Harvey, go ahead.
Hi, I just want to thank everyone. I came here to really just learn. I'm the campaign manager for James Erb. So really this is just for other public attendees. And I just wanted them to feel comfortable reaching out to me if they wanted to volunteer, if they're passionate about the issues that we were talking about today. I wondered if I could like drop my email somewhere for other public attendees to feel comfortable reaching out to me.
Cole, you could go ahead and submit your email information to Jill Nixon and she can pass it on if anybody wants to participate in submitting information to you.
Thank you.
Cole, if you don't mind hanging on after we end the recording and meeting, I can get your contact information and give you mine.
Sounds
Thank
great.
you.
Thank you.
No other hands are raised.
Thank you, everybody, for your participation in today's meeting. And it looks like we're going to adjourn a little bit early. I know you seem all very disappointed when we adjourn early. But if there is any other information that we didn't touch on that you would like to see at the next Law and Justice Committee, please let me know, or Arlene. And we should have minutes and stuff up later on. Jill is very helpful with that. Thank you, everybody.
Thank you. Arlene, can you stay behind as well?